you for the invitation to speak to the committee. At the outset, I want to stress that I'm not here as President and CEO of the Canadian Chamber of Commerce, but as a private citizen and as a former minister who was responsible for the creation of the Emergencies Act. Any opinions that I express are solely mine. I hope I can help the committee by explaining our motivation in replacing the old War Measures Act with modern emergencies legislation, by describing the principles that guided us, and by offering some questions for you to consider. I won't offer an opinion on whether invoking the act was justified. I've not seen sufficient evidence to reach a conclusion. I note that the commissioner of the OPP stated last week that the province's intelligence bureau considered the blockades a national security threat a week before Ottawa invoked the act. I hope you'll insist on seeing that assessment and will evaluate the quality of the intelligence on which it was based. Indeed, the committee should press for any information to help Canadians understand the rationale for invocation and test against both the facts of the situation and the deliberately high threshold that is required. Let me briefly provide some history. In 1988, Parliament voted unanimously to replace the War Measures Act with legislation that was designed to help the government respond quickly and effectively to a range of emergencies that went well beyond war or insurrection, while safeguarding Canadians' basic rights. The War Measures Act was enacted in World War I in the heat of a crisis when safeguarding civil liberties was not a priority. It was used in both world wars, partly due to perceived threats from enemy aliens. The government used it to arrest, incarcerate, deport, and seize the property of thousands of Canadians of Ukrainian, Japanese, Italian, and German heritage. The Act's third and only peacetime invocation was during the October crisis of 1970, when the FLQ kidnapped the British Trade Commissioner in Montreal and the Deputy Premier of Quebec, Pierre Laporte. The War Measures Act suspended civil liberties across the country. It retroactively made FLQ membership a crime and required those who'd ever attended any of its meetings to prove that they were not members. It authorized arrest without a charge or access to a lawyer and confinement for up to 21 days, as well as property searches without a warrant. It was outside of the Canadian Bill of Rights, and the Charter of Rights and Freedoms did not exist. We needed a flexible tool to deal quickly and effectively with a range of potential emergencies and to safeguard the rights of citizens, of the provinces, and of Parliament. While no one could predict the exact circumstances, Canada would inevitably face future crises where we would have to protect Canadians' lives and safety, and even the existence of the country itself. However, any powers would be strictly limited and be overseen by the courts and by Parliament. The declaration of an emergency does not absolve Parliament of its responsibilities. Instead, it makes Parliament's role even more important. Now, even the most carefully written emergencies legislation is a blunt instrument. It must be because it needs to cover a wide range of contingencies that can't be managed effectively in any other way. Even if you find that invoking the act was warranted, you should work to make it unnecessary if we face similar circumstances again. Now that it's been used, it becomes easier to invoke. You must not define down the threshold at which extraordinary powers are used to curtail civil liberties. You'll want to scrutinize the arguments for invocation, to ask if the order should have been revoked earlier, and to examine the benefits cited as flowing from it. That it made law enforcement easier is clear. However, the issue is not whether the issue is whether the deliberately high threshold was met, not whether the powers given were useful. Let me touch on this threshold for a moment. The War Measures Act was applicable to war, invasion, or insurrection, real or apprehended. Most importantly, an invocation of the War Measures Act was considered conclusive evidence of the existence of an emergency. It could not be challenged in court. In contrast, Section 3 of the Emergencies Act defines a national emergency as, quote, an urgent and critical situation of a temporary nature that A, endangers the lives, health, or safety of Canadians and is of such proportions or nature as to succeed the capacity or authority of a province to deal with it, or B, seriously threatens the ability of the Government of Canada to preserve the sovereignty, security, and territorial integrity of Canada, and that cannot be effectively dealt with under any other law of Canada, close quotes. Now, Part 2 of the Act adds a further test for public order emergencies, which it defines as, quote, an emergency that arises from threats to the security of Canada and that is so serious as to be a national emergency, close quotes. And it specifies that threats to the security of Canada has the meaning assigned by Section 2 of the Canadian Security Intelligence Act. We used the CSIS Act definition because of the care that had gone into writing it. I don't have time to read that definition to you tonight, but I urge you to do so. It's very important. A public order emergency must meet two stringent tests. The first is to establish the existence of a severe emergency that cannot be effectively dealt with under any other law of Canada. The second is that it must meet a definition of threats to the security of Canada that was drafted to protect Canadians' rights and that specifically provides for, quote, lawful advocacy, protest, or dissent, close quotes. Now, the committee needn't waste time proving that the border blockades and the occupation of downtown Ottawa were illegal, that they infringed the rights of thousands of citizens, or that they cost tens of millions of dollars. The authorities had the responsibility to restore the rule of law and to prevent further damage. It would be hard to credibly argue anything else. Now, the authorities have cited several ways in which the Act helped. For example, unlike other provinces' Emergencies Acts, Ontario's didn't let it press towing companies into service. Additionally, it made it easier to cordon off downtown Ottawa and significantly cut the time to authorize police from other jurisdictions to assist. And of course, the government used it to freeze the bank accounts of people participating in or financing the blockade in Ottawa. The Act clearly made the work of the authorities easier. The issue, however, is not whether it helped the police, but whether the powers they already had could have resolved the problem. The concern is necessity, not efficiency. Now, it's also said that while law enforcement had plenty of legal authority to end the blockades, they chose not to use it. Invoking the Act sent a clear message that our political leaders expected the police to do their jobs. But does that make the Act's invocation primarily political, instead of to provide law enforcement with essential powers that they previously lacked? Would that meet the criteria for invoking the Act? Now, just three other brief observations. First, I hope you will propose ways to ensure that the Act won't be needed in similar circumstances in the future. For example, if Ontario requires powers to order companies to provide services in a crisis, or if it must be made easier for other police forces to help, that's where to change legislation. Similarly, the most novel use of the Act was to freeze the bank accounts of people associated with the blockades. Parliament needs to consider the rationale for such a power and the ways in which the government might use it. There are serious issues about foreign interference in our politics and about how to control the financing of illegal activities, but we must carefully weigh the implications. And any new power should be conferred in a time of calm and not by a regulation drawn up in a crisis. Second, there's this obvious question. If you assume that the invocation was legal, did the Act meet the twin goals of allowing the authorities to respond quickly and effectively in a crisis while limiting the impact on civil liberties? My answer is that it did. We've heard much heated rhetoric directed at how the authorities used the Act, but we should consider how these blockades would have been dealt with in other democratic capitals like Washington or Paris. And we've all seen how the right to orderly protest has been brutally suppressed in Moscow. These international comparisons provide a benchmark for judging Canada's treatment of civil liberties. Now, one final comment. Parliament's responsibilities go beyond judging whether invoking the Act was appropriate and if the specific measures were warranted. Our leaders of all political backgrounds need to ask how we got to this point. The police were called upon to deal with a breakdown in our political system. We can criticize how they did their job, but it should never have been necessary for them to fill the breach in the first place. If we're to avoid much more serious emergencies in the future, we must restore a civility to our politics that allows us once again to disagree strongly on issues without seeing one another as enemies. Thank you once again for inviting me to participate, and I'll welcome your questions and your comments.
Thank you very much, Mr. Beatty. Certainly.